The clarification that's come from the ministry is a step in the right direction. It's a recognition of the fact that there were some intrinsic problems in the draft encryption policy, and that's why the proposed exemptions have been granted. But while the exemptions have been so granted, the intrinsic problems in the policy, draft policy, still remain. Primarily, the fact is that the requirement of users to retain 90 days data pertaining to encrypted messages that they send in the cut, copy, paste format in the text messaging stuff still remains. The problem in the policy still remains, and that's the reason why we are beginning to find that this entire issue of the policy needs to be deliberated at great length. Further, the fact remains is the bigger question we have to ask ourselves: how does this policy contribute towards cyber security of India? The policy is completely silent on that. By giving these exemptions, the policy is effectively pushing almost all users not to come within the ambit of the policy, but to start using these mass encryption products which are exempted for the purposes of not just transacting, but also for the purposes of engaging in various cyber criminal and cyber terrorist activities.
Your first reaction on the policy draft by the government?
There is a draft policy on the national encryption policy on which comments are to be given by 16th October. This draft policy reflects the failure of the government and the industry. Government failure is that they are still insisting for the technology which is now outdated. And second failure is they have yet to ask all the internet companies to get themselves registered before doing any business in India. Now, industry failure is they are not complying with the norms fixed as per the Companies Act and Income Tax Act. But instead of they fulfilling their obligations, they are insisting normal users to do such things which are neither required by the law nor they can be enforced through any such regulations. Now, the first thing is that they are, if insisting that up to 90 days they have to keep all such information. Now, there are two types of information are there. One is information and second is transaction. Transaction, if business transaction is there, so as per Income Tax Act or as per other procedures, they can insist that it can be safeguarded. But for normal information, neither it can be directed as per any law nor as per any draft regulations.
So do you think that this kind of things are interference in the personal life of a public?
Yes, and this is interference. If they are saying that, then from three aspects it can be interference. The first is that it can be violation of right to privacy. The second can be that you are asking normal user to keep the information when your technological device may not permit it, or you may not be interested to retaining those information. So I personally feel that if these regulations are fixing any norms or the obligations to the users, then it is interference in the freedom and fundamental rights of the normal users of the country.